Okay. Hi students, I hope the semester is still going well for you and that if you are having questions, you are trying to contact me and get them answered. I'm always happy to help you. So far it seems like these videos are helping some. I'm sorry that it's taken me till Thursday night most of the time to get them posted, but I just cannot seem to find the time earlier in the week to do it. So at least it's a few days before the quiz is due, and hopefully it will even help you with maybe answering some of your homework questions. It looks like you guys overall as a class are doing much better by now answering questions in the homework. You only actually have this week and next week of regular traditional homework, and then the final week in here is actually a lot of fun. Students find it sort of a refreshing change to the 3 things due for homework every week. It's a legal wrap-up, and the guidelines for that are under the content. And there are some examples under the news section that you can look at to see what other students have done and scored well. So it really is something that if you put some time into and you have fun with it, you should do really well. Since it's 10% of the grade, it can really make a difference in your final grade if you do extremely well. And if you've turned in all of your work on time all semester, if you'll remember, I give you extra credit towards that 10%. And you also have some options to do some extra credit. The very last few pages of the syllabus give you some example choices of things that you can do, like watch a movie and tell me some legal things that you learned from the movie, look up an article and explain how that relates to something that we've learned in the class this semester. There are a few options for some extra credit also in the back of the syllabus, the last pages of the syllabus, that will be due the week before the final week of the class. So there are a few options for some extra credit in here, and with it going towards 10% of the grade, you may find that it's really helpful to try for that. Okay, so tonight we're going to actually talk about Chapter 13, which is about discrimination. It's about employment discrimination in particular. So there's a few laws that try to protect us from discrimination in the workplace, and the main 2 that come from the United States Constitution are from the Equal Protection Clause under the 14th Amendment, that we be treated equally as citizens, and the Due Process Clause of the 5th Amendment, which says that basically we shouldn't be subjected to government wrongdoing, wrongful government action. There's also the Civil Rights Act of 1964. That's probably the most prevalent one discussed in courtrooms today. It's the Civil Rights Act of 1964. It's called Title VII. You've probably heard of Title VII in your experience as a manager if you're already a manager, and you certainly will hear about it if you are going to be a manager and do some kind of leadership role in a business. Title VII forbids discrimination in employment because of the following reasons. These are very specific: race, color, religion, gender, or national origin. So Title VII forbids racial discrimination, discrimination based on the color of your skin, your religion, your sex, meaning your gender, not sexual preference, but sex meaning gender, or national origin, where you were born. If you'll notice, the Title VII does not talk about age discrimination. There's an entirely different law that tries to prohibit age discrimination. So Title VII only applies to businesses if there are 15 or more employees. And if you think about it, it's fair to do that, more fair to do that than applying it to everyone, because we do have some companies in the United States, of course, which are smaller businesses. We call them mom and pop kind of shops. Those places where they're small, many of them, many times they're run by family members, and we wouldn't want to have to disallow them from sort of choosing not to hire certain people because they're trying to keep it in the family. They're trying to keep it a very small business with people they actually know. So if you have a company that has 15 or more employees, though, then they are regulated by Title VII, meaning they cannot discriminate based on race, color, religion, sex, or national origin. This act forbids discrimination in both the hiring, the firing, and the general conditions of employment. So you're not really supposed to be subject to hiring or firing because of race, color, religion, sex, or national origin, nor are you supposed to be subjected to daily basis discrimination while you're working there. There are a few more anti-discrimination laws that try to protect us from being discriminated against at work. Some of them we will talk about in specific detail. There was a Civil Rights Act back in 1866 which forbidded all forms of racial bias arising out of contract. It had to do with contract. If you were not getting a contract because of your gender, then it forbidded that discrimination in that contract. The Civil Rights Act of 1991 specifies that Title VII and the ADA apply to U.S. citizens working abroad for American-owned or American-controlled companies. So not only are you protected by Title VII and ADA here in the United States, if you're working for an American company overseas, you are still protected by Title VII and ADA. ADA, which we will discuss near the end of the chapter, is the Americans with Disabilities Act, and it really just prevents people from discriminating against those who are considered disabled, especially if they are able to do the job. The Equal Pay Act really just means that we're supposed to pay equal pay for equal work. There are a few exceptions to that. Again, we'll talk about that near the end, but we're supposed to pay people equally for equal work. Discrimination, the Age Discrimination in Employment Act only applies to those who are 40 and older. So what's unique about that particular law is if I were a 16-year-old and I can't get my first job because nobody will give me that chance, I can't say, oh, age discrimination and nobody's giving me a fair shake. You cannot use the Age Discrimination Employment Act to help you because being too young isn't protected. It's those who are 40 and older who end up either losing their job or being demoted, being laid off, not being hired because of their age, when they were just as qualified as someone younger. And then there's an executive order, 11246, which just forbids discrimination by firms doing business with the federal government. So if you are a firm doing business with the federal government, you are, of course, also subject to Title VII. All right, so I know that at least on the quiz, prima facie discrimination is a question, so I want to mention it here. Prima facie just means on the face of it. On the very face of looking at the situation, it is evident that discrimination exists. So even though there may be some discrimination that exists, there may be some legal justification which is reasonable for the discrimination. So sometimes there will be discrimination, but there is a defense or a justification which allows the discrimination anyway. But prima facie discrimination just means that there is evidence of discrimination on the face of the situation at hand. So the Equal Employment Opportunity Commission, the EEOC, is the federal agency which is responsible for looking into whether or not there's been discrimination in the workplace. It's responsible for enforcing the federal discrimination in employment laws. They do investigations of claims. If you file with the EEOC that you've been discriminated against at some big business, they have more than 15 employees and they hired you because they did not want to hire someone who was from Cuba. I should say Cuba. They didn't want to hire someone from Cuba. You feel like you were being discriminated against because of national origin. So you would file your claim and they will investigate it and do some kind of response to you before usually 180 days. They will, if they find that there's something legitimate to it, they will attempt to resolve this dispute for you in mediation, sometimes even litigation. And if necessary, they will engage in litigation. They enforce the Civil Rights Act of 1964. They enforce that Title VII. They enforce the fact that you cannot be discriminated against in employment if there is a company over 15 employees based on your race, color, gender, religion, or national origin. Litigation. They will take cases to litigation if they think that you've been discriminated against or that an employee has been discriminated against. They can file the suit for you in court. If they think that there's not necessarily a legitimate case that they should pursue, There may or may not be anything there. They're not saying yes or no, but they are saying that they're not going to take it any further. They find no valid complaint that they want to go forward for, they can issue a right to sue letter, which would give you the ability to sue on your own. You really aren't supposed to sue on your own until you have already filed this with the EEOC and you find that they are not going to take the case for you because they find no valid complaint. Many disputes are resolved in arbitration, whether the EEOC takes them to arbitration or whether the employee themselves try to take it to arbitration. When litigated, the plaintiff has a very hard time of proving discrimination. They only win around 30% of the time. They have a hard time, and I think when we get into it and you see why, what all they have to prove, it's hard to prove discrimination. There's almost always some other reason that could be legitimately offered to explain why that employee did not get hired or is no longer working there. So remedies, if there is some discrimination, especially if the EEOC takes this case for you and they take it to court and they find that the company has discriminated against you, it may include job reinstatement, so you may get your job back pay for the time that you've been out of work, seniority relief, meaning you get that extra pay because you've been there a long time, compensatory damages for any actual damages that you suffered, and maybe even punitive damages. If this is a company that did something maliciously, remember that punitive damages are there to punish, so they would do some really strong, maybe $1 million award to this particular employee to make sure that that company doesn't ever do it again. The EEOC often negotiates consent decrees that require new procedures for wrongful practices. Basically, if they do find that there has been some discrimination, they're going to try to make sure that that company will not be allowed to do that again. So there are two types of trying to prove discrimination in the workplace. The first is disparate treatment. That is that intentional discriminatory treatment. So disparate treatment is intentional. Disparate treatment exists where employers intentionally treat some people less favorably because of race, religion, sex, or national origin. Disparate treatment is where the employer intentionally treats people less favorably because of their race, religion, gender, or national origin. If you notice the first number one, the plaintiff has to prove the prima facie case, meaning there's evidence in the face of it, by showing all of the next 6 bullets. So it's quite extensive that what the plaintiff has to show. The plaintiff has to show that he or she belonged to that protected class, they were in that race, they were in that religion, they were in that gender, they were of that origin. They applied for a job in which the defendant was seeking applicants. The plaintiff was qualified, yet the plaintiff was denied the job. The position remained open and the employer continued to seek applicants even though the plaintiff was qualified and they were denied. And the plaintiff must show that the defendant acted with intent. So that the plaintiff has to show that the defendant intentionally chose not to hire that person because they were from Cuba. That's the example I gave you a minute ago. So because they were Cuban, they would not hire them. They kept the job open. Even though this person could have done an equally perfect job as anyone else, they didn't want to hire them simply because they're Cuban. They have to show that they acted with intent. This is very difficult to prove. Intent is extremely difficult to prove. You'd have to have something like them saying something in an interview like, because you're Cuban, we're not hiring you, or make some really horrible slanderous statements against Cubans in general. It's difficult to show intent. Because if you look at number 2, the defendant's, the employer's case, what they really have to show, if the plaintiff can prove all of those things, the defendant must articulate some legitimate non-discriminatory reason for the employee's rejection. So, for example, they can say, I didn't choose you not because you're Cuban, I didn't choose you because Sally had 28 more days experience than you. That's all it takes. A little bit more experience, a little more education, a little more of a particular credentialing, very easy to show that there were differences in the people applying. One little minute difference in the people applying that could be a legitimate reason is enough for the defendant to prove that it was not a discriminatory action. If the plaintiff can show that there was intent and the defendant is not able to show that legitimate non-discriminatory reason for rejection, then the plaintiff must then show the reason that's offered by the defendant was false. So they'd have to show that, no, Sally didn't have 28 more days of work experience. That wasn't true. She only had 2 more days work experience, or she doesn't have any extra work experience. I don't know what you're talking about, employer. So you can see where the plaintiff's got a lot of burden at the very beginning. Excuse me. Then the defendant only has to show something very skewed, very minuscule difference, some really skewed, tiny difference in the reason they didn't hire a particular employee because of more experience, more education, more credentialing, better work history. It could be so many things. And then if they prove that there's a legitimate reason, or if they don't prove it, the plaintiff still has to show whatever they're saying it's false. So it is extremely difficult for the plaintiff to win, to show intentional discrimination. Not that they never win, but it's difficult. 30% success rate is not very high. So the other type of employment discrimination is disparate impact. There's a discriminatory effect. So disparate impact exists where employer uses legitimate employment practices, so they're doing the right things, but despite that neutrality, there is a heavier burden placed on the protected class than other employees. For whatever reason, something that they're doing, their employment practice, is placing a heavier burden on those employees. So one of the cases that the book talked about was Griggs versus Duke Power Company. And that was where there were employment tests for a person to work in the office rather than working out on the line, rather than working in the actual manufacturing part or in the mine. They had to do employment tests, take employment tests to show that they could work in the office. And in fact, some of the cases that we've talked about or that we've read about, they had to have, like, for example, a high school diploma credential. And what they found was that has a negative effect on at least a certain percentage of employees, especially if you start looking at employees by gender, looking employees by race, looking employees by origin. Sometimes they're going to have a lower high school finishing rate, and the reason being it's just sort of the way that it is. And so what they found was that you didn't really need a high school diploma to be a better worker in the office. So sometimes employment tests which operate and they disproportionately exclude a certain class of people, whether it's based on their race, their religion, their gender, their national origin, then even though the company is trying to do the right thing, it ends up impacting a group more than it would impact another group. And so it's called disparate impact. So here the plaintiff has to show, the employee has to show that there is a specific employment practice or policy that caused the alleged disparate impact. So there's some practice that's causing this impact that negatively affects one group but not all groups. The employee also must prove, often statistically, that that protected class is suffering this adverse or disproportionate impact caused by this employment practice or policy. And the defendants, the employer's case, they just have to show that if the plaintiff succeeds above, the defendant must demonstrate that the employment practice is both job-related and consistent with business necessity. So if the practice that they're doing is related to the jobs and it's something that the business needs to find out to conduct business accordingly, then they'll be able to show that maybe there is this discriminatory effect, but it's justified in some way. And then the plaintiff's response to that is the plaintiff must again demonstrate an alternative, less discriminatory practice, that something like that is available, but the employer refused to adopt it. So let's say that the employer is doing something, these employment tests, they're having this effect on this particular class of people. In this particular case, it was that these employment tests were affecting African Americans more significantly than it was affecting any other group of employees. So if the plaintiff can show that, and the defendant can show, well, but it is job related. We want them to have a little higher skill set if they're working in the office, and it's consistent with business necessities. Other businesses are doing the same kind of thing, and we want to make sure that the people in the office are highly skilled. Then the plaintiff has to show that there's some other way, some other business practice available that would be less discriminatory in nature, and they just chose not to do it. So again, you're talking about plaintiffs thinking outside the box, trying to put themselves in a business position to think, what could this employer do differently so that it wouldn't discriminate against me? They could do something differently that would have less of a discriminatory effect, and they just chose not to do it. So this is where good attorneys come in. Good attorneys could help those plaintiffs think of that, because you can see there's a lot of burden on the plaintiff's side. So it is very difficult to prove discrimination in employment, because often there is some legitimate reason for the discriminatory practices, whether they're just intentional discrimination or discriminatory effect. There's some justification which helps them overcome that. Not that it's right or wrong, but they can overcome it. So here's a few other employment discrimination statutory defenses. So let's, excuse me, let's say that the plaintiff on one of those two, whether it's discriminatory intent or disparate impact, because there's the impact, disparate treatment or disparate impact, there are some defenses. So the plaintiff comes out swinging and shows that there was that discrimination, whether they were intentionally discriminated against or that there was a discriminatory treatment of some kind that adversely affected them. Then the defendant, the employer, still has some defenses which can help them get out of this discrimination. One is seniority. An employer may lawfully apply standards of compensation or conditions of employment pursuant to a bona fide, which means good faith, seniority system, provided it is not the product of the intent to discriminate. So they can treat people differently based on how long people have worked there. So for example, you might get more benefits the longer you work there, or you might get a higher salary the longer that you work there, or you might get automatic raises every so few years. You might get more time off per month the longer that you've been there. So seniority is a way that employers can treat people differently, even within the same company, based on the fact that people have been there or served a longer period of time. Another way that employers can treat people differently is if there's a bona fide occupational qualification, which again we will talk more about in a minute, but the qualification has to go to the very essence of the job. So for example, let's say that I am applying to UPS, and so is Bob. Bob's next to me, Bob's male, I'm female. We're applying to UPS. The very first thing on the application when we're going to fill it out is, can you lift 75 pounds? Bob's going to check yes, because Bob can legitimately do that, and I would have to check no, because I legitimately probably can't do that. Maybe, I don't know. But I'm going to say no, because I probably can't. So sometimes, because at the very essence of the job, you have to be able to perform a certain task, They can discriminate against you because you cannot meet that certain skill. So because Bob can lift 75 pounds and I can't, it's not a male or female thing. It's because Bob can lift and I can't. So sometimes there's a bona fide occupational qualification which allows, even though there's this disparate impact, females are going to get probably a less likely ability to get that kind of job than males might be able to get. So there is that disparate impact there. It's not intentional, but it's needed for the job. There's this sort of treatment that's treating me as a female differently. But it goes to the very essence of the job. UPS, you got to be able to lift a lot of weight, do it fast, carry it in and out of a truck. I probably couldn't do that, to be honest. So bona fide occupational qualifications allow employers to treat people differently sometimes based on a qualification that goes to the essence of the job. And then employee testing, only job-related tests which are supported by detailed statistical evidence as to their scientific validity are lawful. We can't just give test to start weeding out and treating people differently. The test has to make sense. It has to go to the essence of the job also. Okay, and usually we're going to have to show that there's some statistical difference that a certain set of people are not doing as well on these tests. But let's say that you are trying to hire a legal secretary who can also speak Spanish. This might happen in Florida. We have a lot of Hispanic speaking people, and the further south in Florida you go, the more you might find that Spanish might even be the first language compared to English. So let's say that there is a test when a person is opening an ad for the law office for people to apply to be the legal secretary, but there's a test showing that they can legitimately speak and write in Spanish as well. We want a Spanish speaking and English speaking, so a bilanguaged person, someone that has a bilingual ability. And if that person, if you do those tests and you find people that can't do that, then employee testing would be okay because it goes to the essence of the job. We're asking for someone who's bilingual, someone who has two languages, and we need to see if they can speak both languages to do this job. So that would be okay. National origin and racial harassment. Title VII, employment discrimination, including harassment, forbids discrimination based on national origin. So this is what I was giving you examples of before. I don't want to hire someone because they're from India, China, Uruguay. It doesn't matter. Wherever it is that this particular national origin is that the company doesn't want to hire from, they can't do that. They can't choose not to hire someone from a different country just because simply they're from a different country. As long as they're a legal U.S. citizen, we cannot discriminate against anyone based on their race, gender, national origin, or religion. So the Supreme Court has even gone as far as saying sometimes there are certain phrases in employment settings which cannot be excused as rudeness. They may, under the totality of circumstances, add up to discrimination, so severe that it creates an abusive work environment. So you have to be very careful in your work situations, especially when you're the manager, not to say things that could be taken offensively. If it would hurt your feelings, you probably shouldn't say it, right? So it could be things like, for example, there was a case when people were passing around a hangman's noose around the office. That was seen as discrimination because it would really offend someone of a particular origin or race. You also can't say things like your type or your people or you people don't understand, because then you're classifying a whole lump of people at one time, and it could be seen as discriminatory language. So you have to be very careful. Just understand that you cannot discriminate against people based on their race, which is also the same thing as color. Race, color, national origin, religion, or their gender. So bona fide occupational qualification, we talked about that a minute ago, but that is a defense. It is a way for an employer to show that discrimination, even though there may be some discrimination, it really isn't an intentional discrimination. It's needed to do the job. So sometimes disparate treatment or disparate impact support discrimination claims. However, the bona fide occupational qualification helps the employer get out of it. The employer can prevail by establishing a BFOQ defense, including showing that there is a relationship between the classification and job performance, showing that it's necessary for this classification to have successful performance on the job, and that job performance affected by the classification goes to the essence of the employer's business. So like I gave you the UPS example, maybe another example would be, that you have to run a certain distance in a certain amount of time to apply for the police force or the fire, to be a firefighter, or in the Army. You have to run for certain positions. Obviously, in those kinds of fields, you're not sitting behind a desk all day. You're not even sitting in the car or in the fire truck or in the military Jeep or whatever. You are on the front lines running. And even if you happen to have a desk job, there are going to be times where on the job you have to step up and run. So let's say that they have a test of some kind or a requirement that you can run a certain amount of distance in a certain amount of time. Well, maybe there is discriminatory treatment. Maybe they're doing it intentionally, or maybe it's just affecting a gender or a certain class of people more than others. However, if there is a need for this, because this specific requirement goes to the very essence of doing a good job in this field, then they're going to be able to show that it was a bona fide occupational qualification. Therefore, it is a defense to discrimination. So discrimination is lawful where gender, religion, or national origin happens to be a bona fide occupational qualification reasonably necessary to the normal operation of that business. So it's necessary for the safety or to do the job. Race, however, race is never acceptable bona fide occupational qualification. Race is never going to be an acceptable bona fide occupational qualification, because you can't say someone can't do the job because of the color of their skin. So race is never going to be an acceptable bona fide occupational qualification, which would allow an employer to get out of discrimination. However, the BFOQ, discrimination can be lawful where gender, religion, or national origin are necessary bona fide occupational qualifications to do the job because of safety. Okay, equal pay. The Equal Pay Act is just really requiring that there be equal pay for equal work. This is a very key phrase. Equal pay for equal work. That means exactly the same kind of work. It is sort of unfortunate, and it changes, fluctuates a little bit, but as of 2007, women were earning about 77 cents for every dollar earned by men. That goes up and down. In the economy as it is right now, it would probably be more similar to what you see there. The Equal Pay Act of 1963 forbids discrimination on the basis of sex. And when this was written, sex didn't seem like such an maybe inappropriate word. So I keep putting gender in parentheses so that you understand that it's gender-based. Equal Pay Act forbids discrimination on the basis of gender. So women must receive the same rate for the same kind of work as men do. On jobs requiring equal skill, equal effort, equal responsibility, performed under the same working conditions. So if you see there are 4 opportunities there for people to be paid differently. One could require more skill, one could require more effort expended, one could require more responsibility, and one could be different working conditions. So it's equal pay for equal work, exactly the same kind of work under the exact same kind of conditions. Unlawful wages are allowed if they are pursuant to a seniority system. Remember that we can pay people differently or treat people differently based on how long they have been in a business. A merit system. You can pay people differently even right off the bat, right when you hire them. If their education level is different, if their prior job experience is different, if they have publications where other people don't, if they're nationally known or nationally renowned where other applicants might not be. So if there's some kind of merit system which gives them higher pay or higher benefits or compensation in some way because of these higher expectations, then the merit system would allow people to be paid differently. A system that measures earnings by quantity or quality of production. If someone is producing more per hour than someone else working right along beside them, then certainly they ought to be able to get paid more because they are doing more work, so more effort in essence. And then finally, a differential based on any factor other than sex. So any other reason that they have to pay someone differently. Uh-oh, I don't know what happened. A little webcam. So I'm trying to think of a good example for a differential based on any factor other than sex. But basically, let's just say if someone comes in with NBA status. So John came in with, he played basketball and Jim played basketball. But Jim has also played for the NBA. Jim could be paid higher than John from day one because he might have that extra amount of credential in some way. He might have that extra recognition. So it's sort of like merit system, but it's really anything else other than sex. If there's some other reason to pay people differently other than their gender, it's probably going to be able to be fit into these exceptions. So you can pay people differently based on one of these things: a seniority system, a merit system, a quantity, quality, production system, or any factor other than sex, so other than gender. Lowering the pay of the favored gender to create equal pay also violates that. So if you do find, let's say we find that we're paying males more than females, you can't lower the male's pay to bring them down to the female pay. You have to raise the female pay up to the male pay. So you can't lower the pay of the favored gender to make there be equal pay. Sexual harassment. Sexual harassment is the unwelcome sexual advances, requests for sexual favors, or other verbal or physical conduct of a sexual nature that becomes a condition of employment, a basis for employment decisions, or unreasonable interference with work performance, creating a hostile work environment. So, if somebody is not going to get a job, or is going to be demoted from a job, or is going to lose a job because of these sexual advances, because of some sexual conduct being requested, then certainly sexual harassment is probably happening. But please remember that both males and females can be subjects of sexual harassment. They can be the plaintiffs in a sexual harassment lawsuit. It's not just females and it's not just males, both. There are several questions on the quiz, if I remember correctly, that are related to sexual harassment. So you might just want to look over this section particularly well. 2 types of sexual harassment are quid pro quo and hostile environment harassment. So unwanted harassment based on sexual advances is quid pro quo. And quid pro quo just means this for that. So I'll do this if you do that, or you will not get this if you don't do that. So it's some, I'm going to give you a promotion if you do this, or I'm not going to allow you to advance if you don't do this, or you're going to get fired if you don't do this, that would be quid pro quo, this for that, sexual harassment. The other kind of sexual harassment is a hostile work environment, hostile environment harassment. That essentially means there is some severe and pervasive condition happening as to unreasonably interfere with the work performance to create a hostile, abusive environment. So here, the plaintiff, the one who suffered this hostile environment, does not have to show job loss. They just have to show that they have been subject to sexual comments, sexual pictures, sexual jokes, or sexual aggression that's happening in the work environment. Not necessarily to them specifically, but it's happening in the work environment, and it makes them that uncomfortable to go to work every day. Sexual harassment, again, this is the third slide, so remember that this is heavily covered on the quiz if I remember correctly. A defendant, the employer, is going to be liable for sexual harassment if the wrongdoer was a coworker and the employer unreasonably failed to prevent or remedy the harassment where the management knew or should have known about it. So where the manager knows about it and they do nothing, or where they should have known about it and they do nothing to prevent it or to correct it, not only is the coworker, the wrongdoer, the coworker, liable, the company themselves can be liable. So that's why it's extremely important that you realize that actions at work can directly link back to that employer. Remember vicarious liability? So it's very important that as a manager, you know what's happening with your employees at all times. So if you know or should have known about the sexual harassment and you don't do anything about it to prevent it or to remedy it, then you can be liable yourself. The defendant can be liable if the wrongdoer was the supervisor and the employee suffered tangible employment action because of the harassment. So if you are the supervisor and you're doing the harassing, of course, not only can you be liable, but the company can also be liable. So if the wrongdoer was a supervisor, but no tangible employment action was suffered, employer can avoid liability by showing both that it exercised reasonable care to prevent it and to correct the harassment promptly, and that the employee unreasonably failed to take advantages of those measures. So if the wrongdoer is the supervisor who is doing the harassment, the employer can avoid liability if they show that they tried to exercise reasonable care to prevent it. So like maybe they moved that manager out of that area so he could no longer harass that particular employee, and that the employee failed to take advantage of those measures. The employee decided to keep going and seeing that manager on the sidelines anyway. The employer is probably going to be able to get out of that liability. The employer cannot retaliate. Once someone has said there's sexual harassment happening to them as an employee, the employer can't fire them for bringing this claim forward. So the employer is not supposed to retaliate against them for bringing sexual harassment to the forefront. Excuse me. Affirmative action is simply a means of remedying past discrimination to prevent future wrongdoings. Affirmative action plans are meant to seek out minorities for hiring and promotion, and they often employ very specific goals and timelines to measure their progress. Courts will uphold and have even applauded affirmative action efforts as long as they are also not being discriminatory in nature. So in one of the cases, United Steelworkers of America v. Weber, the court upheld affirmative action where there was a plan. It was designed to open up employment opportunities for African Americans in occupations which had traditionally been closed to them. The plan was temporary, and it did not unnecessarily harm the rights of white Caucasian employees. So affirmative action is going to be usually upheld by the court. They're okay with it. They applaud it as long as it's not going to somehow then cause reverse discrimination in some way, or it's not going to single out a whole nother different type of employee. So affirmative action is upheld if it's also not discriminatory in nature. Religious discrimination. Title VII forbids discrimination on the basis of religion. People cannot choose not to hire me because I'm Catholic or Protestant or Jewish or Muslim or Buddhist, or it doesn't matter. Religious faith has to be sincere and meaningful. It cannot be done just as a sham to achieve certain advantages. You can't say, hey, I'm a Seventh-day Adventist because you never want to work on Saturday. It has to be a legitimate, true, faith-based interest. But Title VII does forbid people from discriminating against you based on your religion. And they have to try, employers have to try to make accommodations for you as long as they're reasonable. Employers must take reasonable steps to prevent and remedy religious harassment. But employer does not need to go all out to do it. They only need to bear a de minimis, which means minimal, de minimis cost to accommodate these religious differences. More than that is considered an undue hardship for employers. And so the courts are looking at this reasonable accommodation. Is it a reasonable accommodation? Is it something that's not going to really put the employer out in any way? Then it's going to be considered de minimis. If it's going to really put the employer out, like I only have 3 workers and I am a retail store which is open on Sunday. I only have 3 workers and one of them says I can never work Sundays. I'm Christian and I can never work Sundays. Remember, Title VII only applies to those with 15 or more employees anyway, so I would probably be okay. But because that would really put a huge damper on my ability to conduct business with only 3 employees and one wanting never to work on Sunday, I would probably be able to get rid of that employee or say, the only thing I can do for you is give you every 3rd Sunday off. Just rotate it. So as long as it's some reasonable accommodation, that would be sufficient. It doesn't have to be a large accommodation. So de minimis cost to the employer is what's key here. But remember that Title VII only applies to companies with 15 or more employees. Americans with Disabilities Act, the ADA Act. It forbids discrimination in employment, public accommodations, public services, transportation, and telecommunications against disabled individuals or companies with 15 or more employees. Disabled can mean that someone actually has a physical or mental impairment, which substantially limits one or more life activities like walking, seeing, hearing, or manual labor. So they either have a physical or mental impairment, or they have a record of having it in the past. It's on file somewhere. There's some file that someone has started for them that gives them some kind of accommodations, or they're regarded as having an impairment. They're treated by others as disabled. So maybe this person never was even really disabled, but if they act like, let's say they act like they can't hear and they've been treated by others like they can't hear, and they've made accommodations to sit closer during certain exams or to sit closer to the front to hear. And so maybe they're really not even, didn't lose their hearing, but they've been treated like that, then they may be able to be protected under the ADA Act anyway. The employer may not discriminate against a qualified person who can perform the essential functions of the job. Employers must make reasonable accommodations for disabled employed and applicants. They don't have to do anything unreasonable. If it's too expensive, it's going to be considered undue hardship. They're going to be able to get out of doing something too expensive because it's undue hardship. So let's say that there is a simple computer program that they can install on the phone so that someone who has a hard time hearing and seeing would connect to their computer to make the phone a lot louder so they can hear better, and the computer would automatically be in huge font so they can see better. If it's a couple $100 for them to install that on the computer, that's much less invasive, much less expensive or substantial or even disruptive than having to hire a full-time interpreter to sit with this employee who's now going to have to interpret the language and what's happening because they truly can't hear anything, and is going to have to put Braille throughout the office because they can't see. So you can see that that would be much more substantial and invasive and disruptive to that business. So the employer just has to take reasonable accommodations to try to help someone with a disability have a fair shot at a job. And again, this is only applies to companies with 15 or more employees. And the employer cannot discriminate if the person is equally qualified and can perform the essential job functions. If they cannot perform the job functions, then they're not discriminating against them because they're not able to do the job. And this is our final slide for tonight. It's the ADEA, the Age Discrimination in Employment Act. So this is going to be proved, again, either through intentional treatment, so intentional discrimination, or through that disparate impact. So intentional discrimination or disparate impact. There was some impact that affected older employees. The ADEA, the plaintiff must show that he or she is 40 years old or older, that they are qualified for the position, and that they were either not hired, they were terminated, or they were demoted while a younger person received more favorable treatment. So they've got to show that they were 40 or older, they are absolutely qualified as anybody else, and that they were not hired, or they were terminated, or they were demoted while a younger person received more favorable treatment. So you've got to prove several things again to be able to use the Age Discrimination Employment Act. And again, it does not protect anyone under 40. So you can't say because I'm too young, I didn't get the job. The employer can defend against age discrimination by showing that the termination was based on a legitimate non-discriminatory reason, or the reason they didn't do the promotion, or the reason they didn't get that other job within the company is because there was a legitimate non-discriminatory reason, like there's been poor attendance by this employee, or there's been poor performance, or they're not able to run the mile in 10 minutes like they used to be able to do. So if there's termination or a refusal for a promotion because of age, sometimes employers are still going to be able to show a legitimate non-discriminatory reason for allowing that to happen. Or the employer can defend by showing that age is a bona fide occupational qualification, that the employee of a certain age is needed so that the job can be done safely and efficiently with the work in question. Like pilots or in the military, after a certain age, you can no longer legally fly or pilot a plane on your own. And of course, in the military, you are not allowed to re-enroll after a certain age. And they also don't want you actually serving after a certain age. So because it would go to the very essence of the job, of you being able to do your job as well as a younger employee could do it, then the employer can get out of, defend against that discrimination because it is a bona fide occupational qualification. So again, I'm going to post the quiz overview, which will help you look at the terms that are going to be on the quiz, and I will post this again under the content section. I hope that this will help you through this discrimination chapter. Students usually find this chapter pretty easy to understand compared to the first couple of weeks. So last week and this week are pretty common sense, as will next week be. So next week is also, when we look at consumer protection, a week that students find easy. So I think that if you have stuck through to this far in the semester, you're going to find yourself feeling better about the class and feeling better about the material, because it does seem to be easier for students. So I hope that you are enjoying the class. I hope that you are calling me or emailing me if you do have any questions. I want to be here to help you along the way, and I we'll be posting the quiz overview so that will help you understand what's on the quiz. Good night.